Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning.
Good morning.
Now that we're all seated, you may feel free to remove your mask for the purpose of this argument. You're not obligated to, but you're free to do so. We are here for oral argument in CR20 0046, State of Arizona versus Dustin Lee Brey. As you may know, we record and live stream these proceedings, so please give your name and the name of your client when you begin for purposes of the recording. According to current protocol, you will each argue from counsel table. You have a maximum of 20 minutes per side, although you're not required to use all of that time. We do require you, however, to keep track of your own time, including any time that you would like to reserve. We understand that the time clocks are at the podium and that you may not be able to see them clearly. Please feel free to do what you need to do. If you'd like to argue standing up or if you'd like to periodically stand up to be able to check your time, feel free to do that. We'll try to give you signposts as we have a moment to interject those. Do keep in mind we've read all of the briefing, we've reviewed the record, we've already discussed this case in conference. And with that, you may proceed.
Thank you. Judge Perkins, Judge Brown, Judge Gass, good morning. My name is Kenneth Ray. I represent Dustin Brey, the defendant in the lower case. And to help me keep track of my time, I've got a little timer on my clock if the court would permit me to use that. I will just reserve whatever time that I don't consume. I think that would probably be the easiest for me. I would, with the court's indulgence, like to digress just momentarily. I turned 67 years old 8 days ago, and I'm just about to finish my 36th year of practice. And so I want to give some special thanks to Judge Brown for affording me perhaps what might be my last opportunity to speak before the Court of Appeals, because I am clearly looking in the face of retirement soon. And I also wanted to thank Judge Brown for the opportunity he's given me in the past, and I don't think I ever got to thank him for it. He selected a case of mine that we got to present before the high school in Mojave County. And I really appreciated that opportunity, and I wanted to personally thank him for that. I think, as you can see through reading the transcripts in this particular case, that I was dealing with a new judge in the criminal context, Judge Carmen, a very wonderful judge. Frankly, I can't say enough about her, how well I thought that she conducted herself in this trial. I was dealing with a young prosecutor who I think this was his first felony trial. And so if you perceived in the course of reading these transcripts that I was a little bit tough on either of them, it was perhaps for a purpose. And I think I expressed it, at least in some occasion during the course of the trial, by saying, look, Mr. Lowe, I just want you to become a good prosecutor, or words to that effect. And I truly meant that from the heart, because as I have witnessed the presentation of cases in the trial setting and before the courts of appeal, it strikes me that it's over the years has just really become an evolution. We sometimes take cases that are of seeming insignificance, but after we look at them more closely, we see that they carry a great deal of significance and importance in particular issues. For example, this is a simple marijuana case, really, at its lowest level. But I think that it presents some significant issues. And so I appreciate Judge Brown and the court collectively giving me the opportunity to kind of perhaps point that out. I never thought that I would be at this close to the end of my career preparing and arguing a case in the face of a pandemic, in the face of protests and violence in our streets, the vehement anger against law enforcement. I never thought I would see that. And I'm sad that I am seeing it. This is not a case against law enforcement. This is a case to try and make the system work, the system to be better for the protection of law enforcement, for the protection of the accused, for the protection of the Constitution, and for the protection of the public.
Well, counsel, if you're saying this is a case about protection, and I understand you've got a lot of experience, how many years do you want us to hold, or the police, I should say, to hold a vehicle on what becomes a misdemeanor marijuana charge? This isn't a case of commercial marijuana trafficking. This is a personal possession. So that maybe down the road, years from now, somebody says, I don't think the traffic was merited. I think the light was working. Those happen every day. I mean, we're talking about, your suggestion is that we hold, or the police hold these vehicles for years. Why would we hold vehicles in that way?
I don't think, Judge.
Justify.
Judge, Judge Gass, I don't think that I'm asking to hold it for years. I'm thinking it's appropriate to hold it for long enough until we can conduct independent testing. When we get into a situation where we evaluate the case and we see what the potential issues might be, this is from the defense perspective, and frankly, the prosecution perspective should anticipate this as well.
What would that time frame have been in this case?
In this, well,
multiple years?
Oh, no, I don't think so, Judge. Early on, I think the record bears this out. I can't pinpoint the number of months it may have been. But as we ultimately prepared the case, we determined, well, we need to prepare this motion to suppress, which is part of the complete defense that the accused is entitled to. We request the examination.
Let me ask you this then. You're saying that you think the rule should be every time there is a stop that results in a charge, that if the stop is based on something not working with the vehicle or some aspect of the vehicle, it's jacked up so that the wheels are too high, the light doesn't work, a turn signal isn't functioning, that the police should seize that vehicle for an extended period of time, because what you just talked about is at least a couple of months, and it would be in every case.
Not necessarily. I think that what we have to have is a situation where there is working between the parties. For example, in the situation where the light is alleged as the basis for the stop, it's in the police reports. They need to hold that vehicle long enough to send at least notice to the other side, to the defendant or the defense counsel, that, look, we're going to release this vehicle on such and such a day. If you want to do any testing or so forth, then let us know right away. Well, there was no such notice given in this situation.
Well, there's no requirement of such a notice. You're saying you're adding a lot of steps to an arrest for a simple possession of marijuana. I'm going to ask you, is there any case out there that you can point to that says the police should hold a vehicle based on an arrest because a part of the vehicle isn't working?
Can I point to a specific case? No. The answer, though, I think lies in the California versus Trombetta case, which is applied in Arizona as well. And I cited that at the relevant provision at page 16 of the brief. Under the Due Process Clause of the 14th Amendment, criminal prosecutions must comport with prevailing notions of fundamental fairness. Fundamental fairness, in my view, Judge, is unique to the individual case. If we are talking about a unique case of a stop being predicated upon a light not functioning correctly, then, and it's in the police report, state knows about it, defense knows about it, law enforcement used that as the basis. They don't want to hold the vehicle any longer than is necessary, especially against a legitimate rightful owner, which wasn't in this case.
Does that matter either way? They could release the vehicle, and it wasn't the police that released the vehicle. It was a mistake by the towing company, not the police.
Arguably that is true, but also arguably law enforcement should have placed a hold on that vehicle until such time as the county attorney's office determined that it was appropriate to release the vehicle.
Okay,
We
now
see
we've
this
got-
in
now
forfeiture.
We've got a standard that you've used. Let me unpack that.
All right.
Just because someone's arrested doesn't mean they get charged. In fact, charging decisions can take a long time. A lot of people right now are being charged, as you recognize, because of the pandemic. That doesn't mean they won't be. So your suggestion is they have to hold the vehicle until a charging decision is made?
Well, that's certainly out of my control as a defense
But
attorney.
you're asking us to set a standard, to say that in what I don't consider this a very unique case, it's not the first person to ever be pulled over and to find marijuana in the front of the car and to be arrested. So if you're saying that under those basic facts, and there are thousands of those cases every year, that the vehicle should be held, and now you've suggested it should be until a charging decision is made. You need to tell me how long you think it needs to be held, because we're taking someone else's property rights in the name of this.
And at the same time, if I'm following your logic, Judge, you would be sacrificing the rights of the accused to be able to appropriately challenge if you don't hold on to the car.
Okay, let's unpack that a bit, because we're not talking about challenging the crime. It's not that they released the marijuana, for
Right.
example. We're talking about not a challenge to the crime, but a challenge to the search. So let me ask you this. Let's say they had searched a house for some reason, saying they thought they saw flames in the window. Do we have to secure the house too until such time as a charging decision is made? Because they had the basis for the search needs to be protected until the charging decision is made.
I think that you have to evaluate it on a case-by-case basis, case-by-case situation. I don't know that you can necessarily bright line any of this, but you have to look at it in the totality of the procedural circumstances as they exist and follow the guidance of California versus Trombetta, that in the interest of due process, follow prevailing notions of fundamental fairness.
Let me ask you
That's
this.
my suggestion.
Because in the stipulation before trial, there was some thought of the stipulation seemed to say we agree that one tail light wasn't working, but the license plate light was, correct?
That was the affidavit and submission in lieu of live testimony by Mr. Brey.
And so, well, couldn't this officer have made a stop based only on the tail light?
I think that would fall squarely under Livingston, which under Arizona law at the time that it existed, did not require anything but one red light to the rear. So even
If the officer make a decision in public safety, at least let the driver know that they've got a tail light out so that they can fix it. Aren't they allowed to stop? I believe there's a Division II case on that.
that may well be, Judge. But again, we look at it from the testimony that was provided at the time of the evidentiary hearing. I believe that the officer acknowledged that that was not a necessary violation, a traffic violation.
I don't disagree with you there. But I don't think it is a violation.
Right.
Would we look at the subjective? Do we look at the subjective belief of the officer, or what an objective officer would think based upon a missing taillight?
Well,
I mean, maybe the officer didn't know the law.
Well, I think
just take it a little bit further.
Sure.
And that would be what I think what Judge Goss was alluding to was the community caretaker function. That why couldn't the officer, say there's the license plate, put that aside for a minute, just the taillight. Why didn't the officer have reasonable suspicion to make the stop?
Reasonable, and I don't mean to be rhetorical with you, Judge Brown, but reasonable suspicion of what? Because it clearly would not have been a traffic violation that he was.
Of a safety issue. I mean, to me, it's more of a safety issue than a license plate.
But apparently not according to the Arizona legislature, who decided that it was not a violation to have but only one taillight to the rear. So
Fair enough. Yeah.
Yeah.
But I believe there is this Division II case it doesn't matter if it's Division II, Division I. There is a case from our court that suggests that would be sufficient, to perform your community caretaking function.
But you see, now this then carries over into other aspects that if I didn't expressly state, I think is implicit in all of this, and especially at the hearing, is that in fundamental fairness to the accused, if the defense starts at the beginning, even before, for example, in Trebus versus Davis and Harrell versus Sargent, that's even before the case gets to a grand jury and a decision has been made. Fundamental fairness and due process requires and allows a defendant to submit what he believes to be clearly exculpatory evidence to the county attorney to be presented to the grand jury. They make the call. That's what happens. But so to be able to present a complete defense can start even before the charging decision. And if that is the case, then fundamental fairness in the unique circumstances of the individual case requires that we utilize and comport with prevailing notions of fundamental fairness. In the unique circumstances of this case, if the basis for the stop could not have been the red tail light to the rear, but rather was this license plate light, which the experienced Officer Winfrey tells his less experienced Deputy Crawford, you see, you thought I have you chasing silly things, or whatever the words was that he used. Then we have a vehicle, Crawford's vehicle, pulled in behind with the sheriff's office in Yavapai County has dash cams, except this particular car. The sheriff's office has body cams, except none were utilized in this particular case. The only dash cam that we have is Winfrey's vehicle, which was parked behind Crawford's vehicle, and spent most of the time looking at his barking dog in the back of the vehicle, because nothing else was visible. So the only person that we have is we have Officer Crawford saying the tail light or the license plate light was out. We have Mr. Brey swearing under oath that no, it was working fine from where I was seeing it. So if the preponderance of evidence is the standard that we are to apply, who are we to believe? Well, the cases seem to say that's the decision of the judge. Of course it is. But if in the absence of dash cam, body cam, or anything else like that, or the ability to look at the vehicle and examine that, the due process interests of the accused, who is under oath saying it was working, dissipates. Just dissipates. And that's how the ruling went in the lower court. Again, we talked...
You have about 4
yes,
minutes
ma'am.
left, just to let
I'm
you
sorry.
know.
You're absolutely right. Thank you for that. Again, I go back perhaps to this, the insignificant nature of the case, not insignificant, but minor type of case, and the important issues that follow. Yes, Judge, I want you to apply a fundamental fairness standard. What that is, it's got to be a nebulous term if we were to look to do it in a bright line way. I don't think that we can do it in a bright line way. I think that we have to look at the individual case, see what happened, see what could have been done, see what is reasonable to have been done, and balance the interests of the state and balance the fundamental fairness to the accused. And in this particular case, I think the balance, when all the ability to record, the ability to photograph, the ability to test, the ability to keep the vehicle long enough for testing, independent testing, even testing by another person in the state's point of view. Just that length of period of time to be able to test and corroborate or refute that which was the basis for the stop as asserted by Deputy Crawford is fair. Otherwise, to do something different and just ignore it is to ignore the concept of fundamental fairness. The opinion in California said, to safeguard that right, the court has developed, quote, what might loosely be called the area of constitutional guaranteed access to evidence, citing U.S. versus Valenzuela Bernal. I think that's a standard that's workable in this situation and should be applied in this unique case. With respect to the second issue, Judge, I see I got about 2 minutes left. Smalley was the driver of the vehicle. Smalley disappeared after he took the truck from the tow yard that didn't belong to him. Whose mistake that was really doesn't matter. The fact is the truck was gone. Smalley was gone. And the state's response, as I perceive it, blames the defense because we weren't able to locate Smalley until the eve of trial. And therefore, because it took us that long to find him, it is therefore our fault. And the state's remarks, or the court's remarks of there's no violation of the right to compulsory process when the unavailability of the witness has not resulted from negligence of the state. I don't know that I was blaming anybody. It was just a reality of the fact that we couldn't find him, but when we did find credible evidence as to where he was, we brought it to the attention of the court, we brought it to the attention of the state. The state makes a phone call to the county sheriff, and that was it. And we're saying, all right, look, give us some more time. And the continuance was denied because apparently, according to the judge, the right of compulsory process was not impacted because there was no negligence on the part of the state. And the state is also suggesting in its response that there was no error or harmless error at most because Smalley's statements were admitted. True, but they were still Crawford statements. They were under Aguilar, which adopts the Crawford standard. We still didn't have the benefit of cross-examination of those statements. To expand those statements by confronting Mr. Smalley through cross-examination, we were limited.
Your time has run, counsel.
Thank you, Judge.
Good morning. May it please the court, Michelle Hogan with the Attorney General's Office on behalf of the state. This court should affirm Brey's conviction because, first, law enforcement's decision not to impound the vehicle in which Brey was a passenger could not have violated his due process rights when the vehicle wouldn't have been admitted as evidence at either trial or a penalty phase. And to the second issue, the trial court acted within its discretion in denying Brey's request for a trial continuance when Brey couldn't say when he would be able to serve a subpoena on his co-defendant Smalley, and also because Smalley's appearance, even if he would have testified, which is highly speculative because he was a co-defendant in the case, would not have changed the evidence admitted in this case. So turning first to the due process claim, here the lost evidence, the vehicle, was not material to the issue of guilt or punishment. And when you look at the Brady, Trombetta, and Youngblood line of cases, it defines material exculpatory evidence as evidence which is determinative of the defendant's guilt or the penalty imposed. And here the entire argument rests on the assertion that this vehicle may have been relevant impeaching the deputy's testimony for the circumstances leading to the stop at a suppression hearing. There's no Arizona case applying Youngblood to suppression hearings. This is just determining whether incriminating evidence will come in at trial, not guilt or innocence or the guilt that will be imposed by the trial court.
But if the stop was declared unconstitutional, how would have that affected? Would that be the end of the case here? I mean, if the truck had been able to be tested, okay, and I think, let me go back and maybe disagree with you a little bit the way you phrased. It wouldn't necessarily be the vehicle that is missing. That's not that missing evidence. I read it as more the inability to test the vehicle. Have some expert, have a mechanic look at it, turn on the lights, check the wiring, see if it, and then that expert, presumably that mechanic, could relay that investigation, that report, and say, look, in my opinion, it's working now. It would have been working. I see no short in the wiring. Perhaps. Assume that's true, for argument, hypothetically. Assume that's true. They were able to get that in. And the court says, I believe that's credible. That's credible evidence. Stop is illegal. Unlawful stop case is over.
Yes, I agree in the sense that if there was an illegal stop and the evidence was suppressed, the state wouldn't be able to prove beyond a reasonable doubt the possession charges.
But you are saying that young blood has not been applied in this context, I mean, to a stop.
Correct. And I mean, this case is the suppression hearing probably would have resulted in the state having to dismiss the charges if the stop had been declared illegal. But that's not always the case at a suppression hearing. It might just be one piece of evidence. But yes, these cases don't apply to that because the very definition of material exculpatory evidence says that it must be determinative of guilt or relevant to the punishment.
I'm going to ask you it in a slightly different way, to think of it this way. Let's say the stop occurred and the vehicle was maintained or not, but the truth of the matter is the light was in fact working. But if the officer held a reasonable belief it wasn't when he effected the stop, isn't the stop still valid?
And yes, I agree with that. The trial court heard the testimony of the officer. He could have believed that the officer saw a non-functioning license plate lamp and then had reasonable suspicion. So whether there was an inspection and it was revealed later that the light may have been functioning that night doesn't necessarily mean that the trial court would have found that the stop was illegal.
So, that's why I think the trial court could have said, I do find in fact it was working, but I find the officer had a reasonable basis for the stop because the officer reasonably believed under the circumstances that it wasn't functioning. It was dim. It had mud on it. There could be any number of reasons why the officer may have thought it wasn't working.
Yes.
But let me ask you this, because a lot of these cases do arise out of a stop, and then the defendant often argues that there's a pretext for the stop. Does the state have any obligation to preserve any of that evidence when it reasonably knows that the defendant may charge that this is a pretext? The vehicle wasn't in fact raised, and I'm just using things that I've seen. The light in fact was working, or the door was in fact functional, whatever it was. The windshield didn't actually have the big crack that he talked about. Do they have any obligation when they do something like that to preserve evidence?
I think under Brey and Youngblood, those line of cases, not necessarily because it wouldn't be material exculpatory, but if there was an argument that, and there wasn't an argument here, that the evidence also would have been relevant at trial to, say, impeach the officer's testimony at trial or, would have some impact at trial, then we do have a solution. We have also Willett's instructions there to protect defendants' rights when it doesn't rise to a due process violation.
Was the Willett's instruction offered by the defendant in this case? Was it argued? I don't think it was. I'm asking.
Yeah,
No.
I don't believe there was a Willett's instruction requested because there wasn't really much discussion about the traffic stop at trial.
And the reality is it's in part because the traffic stop itself isn't relevant to the crime.
Right. That is the decision for the trial court. It's not for the jury to decide whether the traffic stop was in fact legal or illegal.
But is there anything that we do have to do about the fact that defendants often don't have that piece of evidence? It's just a word versus word?
That's often what it comes down to, that it's going to be a determination for the trial court on the credibility of the officer versus the credibility of the defendant saying that he believed the light was functioning. And that's often what it's going to come down to. I mean, sometimes there's other evidence, such as a dash cam or body cam, but not in every case.
And it's not unheard of for the courts to make that finding and actually preclude the evidence.
Correct. And second, even if we were to find that Trombetta applies in a suppression hearing, there wasn't bad faith present because the deputy who initiated the traffic stop couldn't have foreseen the relevance or even the exculpatory value of an inspection of the car for trial or, really a suppression hearing necessarily. So there wasn't bad faith in not seizing that car to allow the defendant to later inspect it. And there was a question about the length of time between the stop and when the request for the inspection. Here, the stop occurred in April 2016. and then Brey absconded, and he was extradited in August of 2017, I believe, back to Arizona, and the request for the inspection was in 2018. So this car would have been held nearly 2 years for an inspection, where neither Brey or Smalley were owners of the car, so it would be someone else's property just for this inspection of this lamplight violation.
But, I mean, the state does have the ability to hold it as evidence. The state often holds very valuable items for extended periods of time pending a trial.
Yes, and I think if this had been a case, for example, maybe negligent homicide involving a vehicle, the state probably would have seized that as relevant evidence or potentially material exculpatory evidence.
So there's some level of proportionality in the state's analysis?
Right, to the fact that this is a personal possession charge. It's not even a trafficking charge, so I don't see how the officer could have foreseen that this vehicle would have been relevant to the charges itself.
Let me ask you to just jump ahead. Let's assume we find that it shouldn't have, the state should have held it. There's at least some suggestion that if that's a violation and that the stop therefore was improper, that Brey himself doesn't have the right to still challenge that evidence. And I just don't see that. I think, and so I'm going to ask you, do you take the position that if the stop in fact was improper, that the suppression would apply to Brey as well?
Based on State v. Gomez, which is what Brey argues extends standing to a person in his position, no, Brey has not shown that he has standing based on that case. That case clearly said that the passenger had standing to challenge the search after what was allegedly a legal stop because the, I think it was drugs, was found on his person. And it clearly said this is not an argument to extend suppression to marijuana found in the common areas of the car.
But in those cases, they weren't challenging the stop, they were challenging the search based on things like consent. This is different. If he's got standing to challenge the stop, how doesn't he have standing to then say that evidence that you found over there, I'm not saying he didn't get consent, I'm saying the stop was improper.
Well, I just want to point out that first Gomez did involve a stop first and then a search, a consensual search. And here, I guess, yeah, we have a stop and a consensual search to the common areas of the vehicle. This wasn't fully brief, but some courts have decided that because a passenger or a non-owner doesn't have a privacy interest to the common areas, even though it's preceded by what was allegedly an illegal stop, we don't want to expand a privacy interest. Some courts have decided that, well, this is still a fruit of the illegal stop, so we will allow a passenger to challenge a search of the common areas of the vehicle. But in Arizona, I just don't think that has been decided, and at least the case that has been cited doesn't give a passenger challenge or standing to challenge the search of a common area of a vehicle. And I mean, that would be another reason why this evidence wouldn't necessarily be material, because if Brey never had standing in the first place to challenge the search, then it wouldn't be material exculpatory evidence under Brady or Trombetta or Youngblood. Also, Brey has not made a showing that he could not have obtained comparable evidence. He didn't say that he had contacted the owner about the status of the vehicle, if he had recently repaired any lights on the vehicle. And he also didn't make any attempt to at least contact Smalley immediately after the stop if Smalley noticed anything about the license plate lamp. So for those reasons, he has not shown a due process violation for the state's decision not to impound that vehicle and for an inspection later on. And moving to the second issue, first, the trial court couldn't have abused its discretion because Brey could not provide a timeline when he would be able to serve Smalley with a subpoena. At the time, he had requested a out-of-court or out-of-state subpoena about a month prior to trial based on information that Smalley may be in Mendocino, California. At the time, just like Brey, Smalley had absconded. A nationwide warrant for his arrest had been issued. Law enforcement hadn't found him for 2 years. So it'd be extremely unlikely that Brey would be able to find and serve a subpoena on Smalley. And further, he didn't have an address. So even if he had obtained an out-of-state subpoena, the California court wouldn't have domesticated it based on just the information that Brey had provided of a general area of Mendocino, California. So essentially, he was asking for an indefinite continuance, not a week or another month, to try to secure Smalley's appearance. And second,
Well, in reality, Smalley could have also fought extradition. This could have been extended for a significant period of time, because he would be being brought here essentially on charges.
correct. And I'm assuming part of the reason Brey was extradited to Arizona on possession charges was because he was on felony probation in another state. I don't know how often defendants are extradited for possession charges to Arizona. But also, even if Smalley had appeared, his statements were otherwise admitted through this recorded statement where Smalley said that the marijuana belonged to him and that Brey had taken a couple of puffs at some point during the car ride. It's highly speculative that Smalley would have testified at trial. In all likelihood, he would have asserted his Fifth Amendment right not to testify. So there wouldn't have been an opportunity to cross-examine Smalley on this issue. I mean, he would be essentially admitting to the very charge on the stand for someone else's trial. That just seems unlikely. And he couldn't show that that would have changed anything that occurred at trial. If the court has no further questions, the state asks that you affirm Brey's conviction. Thank you.
Thank you, counsel, for your arguments. Appreciate your time. Congratulations on your career and your next steps. It's good for our relatively new crop of law clerks to get to see someone with some longevity in the profession to prepare arguments. So we will take this matter under advisement. We'll issue our decision in due course, and court is adjourned.